Rand Paul of Kentucky, who presided over the hearing this morning, at which the committee voted on partisan lines to send a contempt citation to the Justice Department. This is his first interview following the vote. Senator, grateful to you for joining.
Glad to be with you. Thanks for having me.
I want to spend a lot of the time talking through the story you're trying to allow the country to understand and history to understand about Anthony Fauci. But let's talk about it today. Neither of us are lawyers, but we both know there are a lot of legal questions here about what happens next. What's your most optimistic case about what the committee did today? Where could it lead and when to try to get compliance from Dr. Fauci?
You know, my goal all along is to get the truth out. You know, 1 million Americans died in the pandemic, and I'd like to know why we funded dangerous research in China. There's not really any liability attached to that question. Anthony Fauci's opinion on why he funded this research, he can have a different opinion on whether it was dangerous or not. He can have an opinion about, you know, whether or not they're opaque in China, whether or not they've been honest with us, whether the investigation was accurate. But his opinion shouldn't really attach any liability to it. That's what I've been mostly concerned about. And really, it didn't start in 2020. His advocacy for gain-of-function research goes back to about 2010, when he funded research in the Netherlands. And a researcher by the name of Ron Fauci took the bird flu and gave it 8-point mutations and made it more infectious between mammals. See, right now, the one thing that saves us from a disaster with bird flu is that it's an animal virus, goes very easily from chicken to chicken, from bird to bird, occasionally comes to humans, but does not transmit human to human. So to my mind, experimenting to try to make the bird flu more transmissible human to human is a death wish. I think it's akin to monkeying around with plutonium. I mean, it's really, really dangerous. And this is a debate we should have in our country, but it was mostly decided by Anthony Fauci. For his 40 some odd years, he would make these decisions, and many, many scientists disagreed with him. This is the kind of fulsome debate we should have. And so the contempt citation is because he's unwilling, even though he ran these agencies for 40 years, he's unwilling to have a fulsome discussion over this.
I'm going to walk through the chronology with you, starting with gain of function. But what did the lawyers in the committee tell you, or the Senate lawyers tell you? How quickly could this act the committee took today to find him in contempt, how quickly could that yield something productive?
Right. We have hand carried it over to the Attorney General today, and also to the U.S. Attorney in D.C. Ultimately, if there were proceedings over contempt of court, it would be the U.S. Attorney in D.C. But I'm guessing, since this is very high profile, probably there'd be a discussion with the Attorney General. So it's in their playground now. I mean, it's up to them to make the decision on whether or not they pursue this. There's not a whole lot of law with regard to this, but there was a Supreme Court case in the 1890s that said that if you had been given immunity through a pardon, that the Fifth Amendment didn't apply. Because the Fifth Amendment is a protection against self-incrimination. But if you've been given immunity, at least the Supreme Court in that case made that decision. The courts will have to decide whether that's applicable to the current situation. But I guess my concern, because I won't be part of the legal battle, is teeing it up for those who will to determine whether or not it's something they can pursue. And really, one outcome isn't necessarily that he goes to jail, that he's forced to testify. You know, they would come back and testify and we get these answers.
Would you be comfortable if he testified under a full grant of immunity, including from governors, if that's possible? In other words, he said his side says he's worried about a state prosecution. Would you rather he never face any legal jeopardy for what he says, including if he perjured himself, to just let him testify?
The problem with giving someone immunity to lie is they may well just come and lie to you. You can't get rid of the idea that it's wrong to lie. If you get rid of that, then the testimony is absolutely worthless. You have to have some repercussion for lying. But the other side of the coin is, all he has to do is tell the truth. In fact, he can come forward and he can say, yes, I deleted thousands of emails, I destroyed government records, but he could make some kind of rationalization, say, I didn't think there were government records, or I didn't know an email was a government records, and I'm sorry, but I've been pardoned for that. You can't do anything to me. He could say about gain of function what he's always been saying. He didn't think it was gain of function. And I think it's disingenuous, and I think in many ways not honest, but he could have done all of those things and testify. And he chose not to. I mean, he chose to plead the fifth 111 times. And all he had to do was tell the truth. He didn't even have to say he didn't commit crimes, tell the truth that he actually did destroy records, but he doesn't have liability for that.
Yeah. I tell people all the time when I talk to them about your hearings and about you on this topic, there are two things that are true that aren't always true of members of Congress doing investigations.